to provide you with some context with regards to my own personal background, so I joined Cirrus Consulting Group approximately 3 years ago and work with our clients both in Canada as well as the U.S. And prior to joining Cirrus, I spent more than 5 years working with hospitals, health systems, as well as ambulatory clinics across North America on workflow optimization, the implementation of new business processes and technologies, including electronic medical records, to improve patient care. And despite how globalization has really changed the way we consume most products and services, healthcare delivery really continues to be a local business. And from that standpoint, it's very critical for those of you that are attending today's presentation to understand how your office lease agreement plays an integral role as far as being able to deliver patient care and have the community be able to access your services. And what I'm going to talk about over the next 60 minutes is primarily going to be focused on one aspect of your practice, which is often overlooked, and that's the medical office lease agreement. And for those of you that have not had the opportunity to engage us before, I know that there are a number of clients on today's webinar in addition to doctors that perhaps we have never spoken with before. So I do want to set the context for who we are. I think it's very important to understand our perspective as it relates to this aspect of the clinic and what unique insights we bring to the table. So we were founded back in 1994, so more than 20 years ago, by doctors for doctors. So it was actually a combination of different healthcare tenants that we initially worked with, given our expertise specifically within the medical community. Today, we actually analyze more than 1,000 office leases each year for healthcare tenants, a combination of GPs, specialists, and dentists. We negotiate on an annual basis over 500 leases per year, and that's quite significant if you think about just a wide variety of landlords that we deal with, whether it's in a small rural community or a large urban center, such as, for example, Toronto or Chicago. We've negotiated since our inception more than 20 years ago, more than 10,000 office leases, again, for healthcare tenants. And one of the things that we're very proud of is the fact that we do conduct a lot of CE seminars across the country, and we do more than 150 seminars across the country. In fact, I'm going to be in Ottawa tomorrow presenting to a large group of healthcare tenants on this exact topic, which is the negotiation of their office lease agreement. And we are a national organization, so for those of you that are joining us from Canada, this is just a brief synopsis of the doctors that we work with across the country, from as far as Halifax all the way to the West Coast, British Columbia. And this footprint continues to grow. So the more we come across the consolidation of real estate, the more we see healthcare tenants be challenged when it comes to negotiating fair and economical lease agreements. For our U.S. participants today, I want to just highlight some of the clients that we represent across the U.S. region. We actually even have clients in Hawaii, if you want to take into consideration time zones, and as far west as Oceanside, California. So from our perspective, it's very important for us to really bring that unique insight from a local standpoint. And part of the reason why a lot of doctors work with us is just that perspective, having somebody who understands what's happening with regards to real estate values in their particular city or town, and leveraging that information to really obtain the most favorable rent rates on a renewal. Now, I really want you to leave today's webinar with a really different mindset as it relates to the office lease agreement. I think there's a lot of myths out there with respect to what can and cannot be negotiated in a medical office lease. And every doctor has unique needs when it comes to what they're looking to achieve as it relates to their clinic. And so understanding what favorable lease terms are and what provisions are often found in leases will put you in a better path when it comes to negotiating with the landlord. I also want you to leave today's webinar with a different set of knowledge as it pertains to the negotiation of your lease. And if I can essentially provide you with a couple of pointers that's going to help you in your upcoming lease negotiation, then I've certainly done my job. And we're going to talk, part of today's webinar is really focused on some of the technical aspects of the lease agreement from a legal and financial standpoint. And if you pay attention to these particular sections of the lease, you'll find that you'll save thousands of dollars when it comes time to negotiating this with the landlord. And then last but not least, having an action plan is important because, without an action plan, you're walking away from today's webinar not knowing where to start. And so I'm going to share with you later on in my presentation what we call the 7-step process as it relates to negotiating medical leases. And this is the exact process that we use internally within our organization. Mind you, there are many additional subcategories that we focus on, but in a nutshell, I've tried to kind of give you the template, the boiler template that you can use when it comes to negotiating your own medical office lease. So for those of you that are attending today's webinar, what is a lease? I often ask this question to countless doctors, and internally we've had a debate with respect to what is a lease. And what we've come up with is that the simplest way to think about a lease is it's essentially a check. Like every check that you'll ever sign in your career, what it'll identify is the payor, who the check is being potentially cashed by, what is the monthly amount in terms of, in this case, if you think about the lease, it's the monthly rent that you pay. And the difference between a check like the one you see here and your lease agreement is that unlike a check, the lease agreement actually has other provisions. Aside from a dollar amount per month that you're paying to your landlord, the check gets stapled to dozens of pages of legally binding covenants that have impact on your ability to practice in that location and hopefully one day transition and ensure that you're leaving behind a legacy, the legacy that you want as far as patient care. And from our perspective, the medical office lease is very important because first and foremost, every doctor, takes under the project of having to invest a significant amount of time and effort in terms of identifying an ideal location and then going through the process of actually building their clinic. We know that the lease agreement serves as the foundation for your practice. Without the lease agreement, there's really nothing that gives you the right, gives you the security to practice within the location of your choosing. And having to relocate, which I'll get to momentarily, is certainly something that will end up costing you a lot of time and a lot of headache. Not to mention that it is very time-consuming to move, and if you were forced to move unexpectedly, you can essentially be challenged with not being able to offer your patient base the care that they deserve. And when it comes to the 3 components of your practice, the way I look at it is the lease is certainly one component of it, but that's not the only component. And the reason why I want to give you an overview of just the components of your practice from the way landlords see it is every landlord knows that you have a certain amount of equipment within the 4 walls of your clinic. You also have patient charts. You have goodwill associated with running your clinic. And the lease agreement is really the only thing that glues the 2 other pieces together, that connects you to that physical location and allows you to have predictability with respect to being able to offer care to your patients. And if you think about it, without the lease agreement, what are you left with? You're left with some medical equipment and patient charts, but yet if your patients cannot access your clinic, it results in significant disruption to your ability to essentially not only generate income, but to serve those patients. And so the lease agreement has to be properly structured to enable you to offer care to your patients and also be able to have predictability in your current location. And so the obvious question now is, well, if the lease is so important, what attributes should my lease have? We believe that it should provide you with fair and affordable financial terms. What do I mean by that? First and foremost, when I'm talking about fair and affordable financial terms, most doctors think about rent. Now, how many of you know the difference between, say, a gross lease and a triple net lease? So for those of you that are on a gross lease, what you're essentially paying to the landlord on a monthly basis is a lump sum amount of rent that covers not only what we traditionally in a triple net lease call a base rent, but also any charges attributable to the maintenance of the property. It could also include insurance and taxes. So you pay one lump sum amount to the landlord each month, and you don't have to worry about whether or not there are additional costs as it pertains to the upkeep and the maintenance of the property. Now, the norm across North America today is actually what's called a triple net lease. And on a triple net lease agreement, you have your base rent, and you have your proportionate share of the operating cost as it pertains to the building you're occupying. And so what ends up happening is, for most of you, the base rent is only one component of the total rent that you pay if you're on a triple net lease. And the first N in triple net stands for property taxes, the second one is insurance, and the last one is maintenance. And understanding how you can essentially control these multiple variables within the lease agreement will allow you to ensure that you can keep your costs in check, and that your, let's say, for example, your proportionate share of the operating costs within the building are not skyrocketing year over year, and you have predictability with respect to any sort of escalations that the landlord wants to table. The lease agreement, from a medical standpoint, should also provide you and your practice with long-term stability and security. Do you have a good long-term lease? And what I mean by that is, typically the term of the lease that we recommend for most doctors is a 10-year lease agreement with 2 or more options to renew the lease for an additional period of, say, 5 years. So in essence, you should essentially have more than 20 or 25 years of predictability and stability with the location that you're currently occupying. And the reason why this is important is because if you're on a shorter term lease, every time you go to renew the lease agreement, you can essentially expect your rent to go up. The reason being is because most landlords time the negotiation process knowing that chances are with 15 days or 30 days prior to the expiration date of your lease, you're not going to all of a sudden now relocate your medical office. Your patients rely on you and your location, and relocating on short notice typically is not achievable because first and foremost you need to find a location, and then secondly determine how much time it's going to take for you to actually physically move to that location. And there's certainly delays with respect to build out and so on. Now, the third component of an excellent medical office lease, the lease should really minimize your risk and exposure. So what do I mean by that? Today, more than 80% of doctors that we work with, when they initially came to us, had a lease agreement that was signed in their personal name. And the reason why this is important is because when you sign a lease in your personal name, what ends up happening is you're essentially providing the landlord with what we call a personal guarantee to pay that rent and to perform all the expectations set out in the lease agreement. And so what essentially occurs is if your lease agreement is signed personally, you're guaranteeing for the duration of the term, whether it's a 3-year term, 5-year term, or 10-year term, for that duration of time to back up the fact that your practice is going to pay this rent. And if your practice doesn't pay the rent, the landlord could come after your personal and your family assets. And so that's just one aspect of minimizing risk and exposure. The other one that we often like to negotiate with the landlord is an early termination right. Every dentist essentially will have a certain number of years that they're going to practice. Every doctor will, as will every GP or every specialist. And so what ends up happening is throughout the term of the lease agreement, you need to ensure that your ability to basically occupy that space is determined, and most importantly, if something happens to you personally, you have the ability to terminate the lease because you cannot provide your patients with care. The lease agreement should also provide you with maximum flexibility. So what I mean by that, do you have the right to add other doctors to the practice, or do you have to go to the landlord each time and obtain the landlord's approval to add other doctors to the clinic? For many of you within the lease agreement, you're pretty much restricted in terms of what you can and cannot do as far as adding associates or adding partners. And having the lease properly structured to give you the maximum flexibility to add staff to your practice is critical, especially doctors, because again, if you've signed a lease personally, you're essentially saying to the landlord that I'm the only doctor practicing in this location. And for many of you, that's not the case. You have other associates that work with you, and having the lease set up properly to address that is very good, very important. Now, enhancing your ability to potentially sell. Now, all of you are not going to sell your practice, but for some of you, you may operate a type of practice that can actually be sold. And the lease agreement will be integral in allowing that to happen, because within every single lease, there is a mechanism that dictates whether or not that lease agreement and the obligations within it can be transferred to another doctor. And we'll talk about that a little bit later on. Now, a long time ago when I started within the commercial real estate industry, one of the first things that we were taught, many of us attended a very large institution that basically taught us in terms of how to effectively manage lease agreements. And this particular diagram was taken from one of the courses from the International Council of Shopping Centers. They're essentially an organization that represents real estate companies, primarily those that are managing retail leases and office leases. And what we're basically taught from day one was whenever you have a tenant that approaches you with respect to renewing a lease, as a landlord, you should try to ignore their request for as long as possible, with the goal of getting them as close as possible to the expiration date. Every lease agreement has a commencement date and an expiration date. And the reason why we were taught this on the landlord side was because when you're a landlord who's managing a portfolio of lease agreements that are coming up for renewal, your goal ultimately is to ensure that you can collect as much rent as possible when that particular tenant renews the lease. And so the gray part of this particular diagram represents you going into your office every day and being able to see your patients. And slowly and surely, as you get closer to the expiration date of the lease, every month that goes by past the 24-month mark, and the closer you get to the expiration of the lease, reduces your leverage when it comes to negotiating the rent rates, as well as all the other provisions within your lease agreement. And so it's very critical that if you have a lease agreement, that not only are you tracking the expiration date of that lease, but you're also ensuring that you're approaching the landlord ideally 24 months prior to the expiration date to commence the negotiation process with respect to renewal or extension of that lease. And for those of you that do have a lease agreement that has what's called an option to renew or option to extend a term, I would highly encourage you to, prior to exercising that option to renew, that you carefully read it to ensure that you're not locking yourself into a higher rent rate. And I'm going to actually pull out an example from one of our recent client files where you'll see word for word how that particular option to renew was written and why the doctor did not want to exercise it, and if the doctor exercised it, what the repercussions would be. So what's in your lease agreement? The option to renew provision that you see before you is actually one that was taken, as I mentioned before, directly from one of our clients. And the client's lease, obviously for the purposes of confidentiality, we've had to take out the tenant name, and we've switched it with that of Dr. Joe Black. And I want you to actually take a couple of minutes and read the option to renew provision, which is found in more than 90% of leases that we review. and try to understand what the inherent issues could be if you were Dr. Black in this case and you went to exercise the option to renew. So the first thing you'll notice is that this option to renew, it says that provided that Dr. Joe Black shall remain as the tenant. This is an example of what we call a personal option to renew, meaning that if there was ever a change in tenancy, or if there was basically a partnership between the doctors and the shares of that partnership changed hands or the corporate structure changed hands, no one but Dr. Black would have the right to exercise the option to renew. And so if you have an option to renew, it's critical that it be structured to allow you, as well as any of the other doctors you practice with, to exercise that option. Otherwise, the option to renew doesn't really provide you with much flexibility, because chances are that you may actually transition and retire before your colleagues within the clinic, or vice versa. And having the option to be personal to one person makes it very difficult, in fact makes it null and void for any of the other doctors in the practice to exercise it. The second issue with this option to renew provision, which is again the mechanism for allowing the tenant to renew the lease, is that if the tenant has duly and has regularly paid its rent and has performed its covenants and obligations under this lease, and has not been in default. Now, anytime you see a term in the lease agreement where the first letter of that term or word is capitalized, what it means is that it is somewhere defined in your lease agreement. So in this case, the word default would actually be defined in the lease, and the default section in your own lease could be a paragraph, or in most cases, it will actually be several pages long, and it will stipulate under what conditions would the tenant, you, be held in default of the lease agreement. So if the doctor had ever been in default, this option to renew, the right to renew and stay in the current premises, would become null and void. Now, what a lot of doctors are surprised to find out is that most defaults occur because of non-rent related issues. So what I mean by that is, when you think about a default, most of you will probably think about not paying rent on time. But in fact, within the lease agreement, there are various provisions that will hold you in default if you don't abide by them, and they're non-rent related. So for example, one of them is with respect to operating hours. If you're in a shopping center or in a medical office building where there are set operating hours, and you decide that you're going to shut down the office for 2 weeks during the summer, and your lease says that you have to be open Monday to Friday from 9 to 5 p.m., and furthermore, if you were to actually leave the premises for more than 5 days, that would be deemed to be abandonment. Then when you go to exercise the option, the landlord could essentially say to you, sorry, you've lost your option to renew. If you were to refer to Article 7.8 within your lease, you'd notice that you violated the operating hours within our property. And every landlord, for the most part, wants to ensure that if they're leasing space to you, that you're doing what you can to attract traffic to that particular shopping center, that strip plaza, or that office building. And so landlords, can certainly hold you to the letter of that provision and ensure that if you violated that provision, you don't have your right to renew the lease. The other issue with respect to this option to renew example is the statement that any such renewal shall be on the landlord's then current standard form lease. Now, every landlord has a standard form lease agreement that they want their tenants to sign. This is actually really common with a lot of medium and large landlords, and now even smaller landlords that own 1 or 2 properties are making the effort to standardize the leases that they have their tenants sign. If you were Dr. Black in this particular example and you went to renew the lease agreement, the landlord, assuming that you had not been in default, that you were still a tenant operating in that premises, the landlord could place in front of you their then current standard form lease, which would have all sorts of conditions in there that you've never actually seen before. And so even if you were the world's greatest lease negotiator and you had gotten excellent rent rates, excellent term, maximum flexibility, when you went to renew the lease, if you were Dr. Black, this particular sentence in the lease agreement would essentially force you to signing a lease that you've actually never seen before, because landlords update their standard form lease quite frequently, and not having had an opportunity to actually change their standard form lease and negotiated terms within a standard form lease puts you in a very detrimental position when you go to exercise the option to renew. Now, the option to renew provision further goes on to say that in no event shall it, meaning the rent, be less than the rent paid in the last year of the original term. What does this mean? If you had negotiated a rent rate of $20 per square foot when you first moved into the location, and the landlord was kind enough to actually lock that rent rate down for you so that you're not paying an annual escalation, and you had a 5-year lease term, and you were Dr. Black and you approached the landlord with respect to your right to renew the lease, the landlord, if you had this clause in the lease agreement, would basically determine your rent in such a way that it would never be less than what you paid originally, which is $20 a square foot. Now, we have doctors in certain cities and towns that were able to obtain decent rent rates when they entered their lease, but because of the high vacancy rates within their buildings now, the rent that they're paying is actually much higher than what their colleagues are paying in the area. And this is oftentimes because when they went to exercise their option to renew, they had this sort of language in the lease agreement. It said that in no event shall your rent ever be less than what you paid originally. And the reason why landlords put this provision in the lease is because they want to be rest assured that once you enter the lease agreement, they have predictability. At the very minimum, you're going to pay more rent than you paid previously. And it's a great way for them to lock you into an escalating rent rate every time you go to renew the lease agreement. And so this can actually be overcome, and this is exactly why you don't want to sign a lease agreement without paying attention to the option to renew language. And more importantly, for those of you that are currently in a lease, do not exercise the option to renew, because if you have this language in the lease agreement, you can be rest assured that regardless of what case you make with the landlord would have the right to increase rent upon renewal. Last but not least, this option to renew example states that the rent will be based on market rent for renewing tenants in the building. So what does that mean? If you happen to be a practice within a very desirable retail center or a medical office building, the landlord would determine your rent when you go to exercise the option to renew based on what they believe is market rent. Now, typically when you talk about market rent, it should really be based on a rent rate that comparable tenants are paying within a certain kilometer or mile radius of where your practice is located. But many leases base market rent for renewing tenants in a building, which means that if Starbucks decides to renew that particular lease agreement with your landlord at $42 a square foot, and you happen to be paying $28 a square foot, the landlord has the legal right to enforce the higher rent rate because the market rent as per the lease agreement was to be determined based on renewing tenants in the building. So if you're in a particular location where there's a very wide variety of different tenants and there's a range of different tenants within your property, a good tenant mix, it's important to ensure that this is not in your lease agreement. And every now and then, even a doctor who's in a medical office building would pay higher rent if the last practice that renewed the lease renewed at a much higher amount, had agreed to a much higher rent rate. And for those labs or for those surgery centers that are occupying good locations, they're willing to pay more rent upon renewal to secure that lease agreement for an additional 3, 5, or 10 years. But if you're running a solo practice, that rent rate may not necessarily be economical. And so you have to understand that, and this is why having the market rent be based on renewing tenants in a building is never a good idea. The next provision I want to talk about is what's called a landlord's right to relocate the premises. This is found in more than 50% of the leases that we review. What we call it very simply is a relocation clause in the lease. And that relocation clause could be a sentence, or as is the case with this particular example, it actually goes into more detail with respect to under what circumstances can the landlord relocate the tenant. So just like the example previously, I want you to take a couple of minutes and read over the relocation provision that you see in front of your screen, and we're going to talk about what the inherent issues are with having this sort of language in the lease agreement. So the first issue that you'll notice is this particular relocation provision states that the landlord shall have the right to relocate the premises to another part of the center in accordance with the following criteria. So what it's saying is that the landlord can relocate your practice, your clinic, to a different location within the development that they control, as long as the new premises shall be substantially the same in size. What does substantially mean? If you're currently occupying an office that's 2,000 square feet and the landlord decides to relocate you to another unit that happens to be 2,200 square feet, are you going to pay more rent as a result of that relocation? Absolutely, because your rent is based on price per square foot, and there's nothing within this right to relocate or the relocation provision that will stipulate that in no event shall your rent actually not increase. And if you're moved to a unit that's smaller in size, then you should be compensated for that accordingly. You know, what if you're moved to a smaller unit that doesn't allow you to have the consult room or the private office that you needed? So this is very important, ensuring that not only is the relocation clause ideally taken out of the lease, we typically like to ensure that it is not in the medical office lease, but in the event that it is, and you have language here talking about relocating you to different premises, that the premises actually should be identical, ideally, to your current one. If it's not, there should be a rent abatement, a rent adjustment to take into consideration the reduced visibility, access, or just the configuration of the unit you're being moved to. The other issue with this relocation provision, which is again found in 50% of leases, is that related to the fact that the physical relocation of the premises shall actually be accomplished by the landlord at the landlord's cost. So when most doctors see this, they are very happy because they're under the impression that the landlord is going to essentially cover the entire cost of the relocation. But little do they know, if they were to go on and further read the lease agreement, that most leases are going to stipulate, if they state that the landlord is going to cover the cost of the relocation, what the actual cost cap is going to be. And in this case, what they're saying is the landlord is not going to cover relocation expenses that essentially exceed $1,000. And for many of you, your costs of relocation are going to be much higher than that. Not to mention that if you're a doctor who's been practicing in the same location for 5, 10, 15 years, and you're forced to relocate to a different unit, if the relocation clause doesn't stipulate that that unit should be available and ready to be occupied immediately, you may actually be forced to shut down for a period of time. And that's going to significantly disrupt your ability to provide care to your patients. So what are the costs of these mistakes? You know, it's very important to understand what is in your lease, but what impact does it have on you financially? So we talked about relocation. Having to relocate unexpectedly at the end of the term can be quite a headache. Having to absorb a significant increase in rent at the end of the term because, for example, you went to renew the lease agreement and you did not pay attention to the option to renew language, or alternatively, you waited too long to renew your lease. The lease agreement comes up for renewal in the next 10, 8, 6 months, and you've contacted the landlord perhaps prior to that, but you've been ignored. And finally, the landlord has come around 30 days or 60 days prior to the expiration of your lease and has prepared a proposal with regards to the extension of that term, but the rent rate is not attractive at all. In fact, it's much higher than you initially anticipated. And lack of convenient access to care for your patients, that's one that has a long-term effect. And your patients rely on you and the physical location that you occupy to be able to obtain the best possible care. And the lease plays such a critical role in enabling that to happen. Now, a lot of doctors ask me, well, how do we get fooled in the first place with regards to the lease and what we don't pay attention to? And you know, I do want to give you a lot of credit because this is something that's not taught in medical school. You often, you know, learn about the lease agreement during the later stages of your career when you're about to set up a clinic. And a lot of this is trial and error. You end up negotiating the lease terms with the landlord. You find out what works and what doesn't work. Now, a lot of doctors that initially are looking at a space, they're looking at essentially two variables. So if you're looking at a 1,500 square foot office and you're paying $30 per square foot in rent, you'll calculate your costs per annum, and you'll figure that you're going to spend $45,000 per year on rent, and you're going to then calculate, you know, what percentage of your overhead comprises of rent and how that relates to your total income. Now, if $30 square foot rent rate for a 1,500 square foot office equates to $3,750 per month in rent. Now, let's assume that your landlord approached you and was essentially offering an 8% increase in rent, which would equate to $2.40 per square foot. What impact would that have on your clinic? Well, you're going to pay $3,600 per year more in rent based on the 8% increase. That equates to an additional cost of $300 per month, which represents a total cost, if you're on a 10-year lease, of $36,000 over the next 10 years. Now, any of the risks I discussed before with respect to relocation or a badly written option to renew provision can actually cost you $100,000 or much more, depending on whether or not you signed a lease personally, for how long, and what stipulations came attached to the notion of having to pay the landlord a fixed rent per month. And so the way doctors, dentists get fooled is when they're going to essentially sign a lease, they oftentimes pay attention to the first page and yet ignore all the provisions that come after that that dictate your ability to operate how you want within the premises and to ensure the long-term sustainability of your clinic. Now, there are various other traps in the medical office lease, which I don't have time to go through. The one I do want to highlight, and I mentioned this earlier, is what happens if you cannot actually practice medicine within your premises. We like to insert what we call a death and disability provision into every single lease, medical office lease that we negotiate to ensure that, God forbid, something were to happen to you, that you're not obligated to essentially pay the landlord rent when you're not practicing. And for those of you that are about to sign a long-term lease, having this death and disability provision ensures that you don't have, again, unexpected event of being forced to pay rent. And most landlords, if you sign a lease agreement in the event of disability, unless you specifically negotiate this provision in the lease, does not void the lease agreement. And so the landlord still expects to get their rent checks. And having this in the lease is a form of an early termination right that gives you and your family the added assurance that if something happens to you, you're not forced essentially to shell out the rent for the next 3, 5, 10 years, as well as in the event of your unfortunate demise, the lease liability does not become the liability of your estate. The other one I want to mention is with respect to financial statements. This is a provision that we see in a lot of leases where basically the landlord stipulates that at any given time they can request your financial statements, and you have to provide the financial statements to them, and those financial statements have to be essentially audited financial statements. So not only are you incurring the expense of getting audited financial statements if the landlord exercises their right to request financial statements, but also you're opening yourself up to the landlord and disclosing information with respect to how much income you're generating. Now, why does the landlord want to have access to your financial statements? Well, if you think about it, if you have a tenant that's coming up for renewal, they have a lease agreement that comes up for renewal, having information with respect to how much they're earning, how well the practice is doing, puts you in a great position to increase rent, knowing that that particular tenant can afford to pay a higher rent. And in fact, it's common practice within the landlord community when you have a number of tenants within your property to request financial statements from all the tenants and then approach the tenants that are doing best financially and offer them a renewal, knowing that the possibility of them accepting a higher rent rate is greater than if you were to approach a tenant that's struggling financially. And so having renewed the tenants that have a better financial position ensures that you can approach other tenants with the same rent, a much higher rent than what the average tenant is paying in that building. So how do these mistakes happen? Many of you who are currently in a lease agreement may have initially worked with a realtor or broker, and the realtor is excellent at finding a prospective location. They can essentially help you understand the rent rates and whether or not, based on their market research, the rent for that particular site makes sense, is economical, and they'll negotiate the economic terms for you. So meaning, for example, if you're interested in any sort of construction allowance or tenant improvement allowance, the broker can certainly table your request to the landlord and help you secure an offer to lease for that particular site. Now, the shortfall of most realtors or brokers is that they don't have expertise as it pertains to the legal provisions within the lease agreement. And this is where the attorney comes in. And so for those of you that are about to sign a lease, I'd highly encourage you, if you're working with a broker or realtor, that you not only have somebody who's helping you with respect to understanding rent rates, fixturing period, and term, but also somebody that understands what obligations you'd have once you sign a lease from a legal perspective. And there are a lot of attorneys out there, a lot of excellent attorneys out there. The challenge is finding a healthcare lawyer, somebody who actually specializes in medical office leases that can help you and guide you through the process of obtaining a lease agreement that's reflective of how you want to run your clinic and positions you well for an eventual transition. And so the type of organization that you ideally want to work with combines the expertise of the brokerage as well as the legal expertise of a lawyer, and provides you with a full service that allows you to essentially not only understand whether or not the rent for your space makes sense, but more importantly, whether or not what you're legally binding yourself to serves to actually benefit you. Is it fair, or is it one-sided? Does it put all sorts of conditions and strains on your clinic and you personally if you were to go ahead and sign that lease agreement? And so ensuring that the lease clauses, including the relocation clause, as well as any sort of option to renew provision, are addressed properly takes the expertise of not only an individual or organization that understands how landlords play this game, but more importantly, what is important from the perspective of the medical practice owner. Now, I mentioned during my introduction that I was going to share with you more of a tactical plan as it relates to negotiating your lease agreement. And the diagram before you is the Cirrus 7-step medical lease negotiation process. What we do is we basically start off with gathering all the right documentation. This is the orange segment of the color wheel, where we'll basically approach the tenant, if we're working with the tenant, to obtain all the lease documents pertaining to the premises that they're occupying. This includes the lease that they originally signed. For those of them that have renewed a lease, it includes any of the amendments. And for many of you, you're not going to have an executed copy of the lease on file. It actually surprises me to this day how many doctors sign a lease agreement and basically send it to the landlord without obtaining a countersigned copy of that lease back and filing that copy away so that they can have easy access to it if any issues arise. So when we look at a lease agreement, it's important for us to gather the right documentation to ensure that we're looking at all the right amendments, if there have been amendments to the lease, because one simple amendment can change the entire picture of the negotiation depending on what that amendment says. For those of you that have seen landlord change, meaning you've had your property purchased and you've had a change in landlord, it's important to understand whether or not you've signed what's called an estoppel certificate that essentially may actually supersede what was stated in your original lease. And many doctors will go ahead and sign this document when there's a change in landlord, because the landlord, the new landlord, wants to verify the information within your lease, and end up agreeing to terms that are incorrect. If we're to look at the original lease, for example, they did not have the terms that were described in the estoppel certificate. So gathering all the right documentation is the first step when it comes to negotiating the lease. The second step is reviewing all the documents, including the original lease. And for those of you that are in the process of starting a clinic, it's looking at the offer to lease as well as the landlord's standard form lease agreement. And what we do internally is we go through the process of identifying all the clauses and provisions that impact the owner, the tenant, as well as their ability to offer patient care. And we do this by looking for those clauses like for example, the assignment clause, which dictates the transferability of the lease, or the use clause, which dictates what medical services you can and cannot offer your patients. Now, once we've done the risk assessment of the lease agreement, we then conduct market research. Every lease agreement is going to have a defined rent rate. And it's critical for us, if you're negotiating a lease, to understand what's happening with respect to the local real estate market. What is the average vacancy for comparable properties within, say, a 3-mile or 3-kilometer radius of where your practice is located? Does that change the outcome or the potential approach of negotiating the lease with the landlord? Absolutely, because if you're in a building today that happens to be fully occupied and there is very little vacancy in the general area, then you don't have as much leverage when it comes to negotiating rent rates. And chances are that if you're paying, let's say, $26 a square foot, and you approach the landlord and you want a rent reduction of $4 a square foot, the landlord is going to reject your proposal, knowing full well that if you decide you're going to relocate it's probably going to take you a year to find a comparable location. So market research, looking at rental rates and vacancy rates, is a very important process that we follow. And if you've noticed up to now, we've actually not even contacted the landlord yet. We've gathered the right documentation. We've reviewed and identified all the provisions within the lease. We've conducted market research, and yet we haven't even picked up the phone yet and contacted the landlord. Now, what many tenants do, and this is a huge mistake, is their lease is coming up for renewal, and they'll immediately call the landlord and begin the negotiations without having done any research, not having understood what's going on in the general market, and not basing their requests on comparable data that is factual, that can be presented to the landlord, that will help you make a strong argument as to why you should obtain that rent that you're looking for. A big part of our process also has to do with outcome and strategy development. So after we conduct a market research, we spend a lot of time talking about what are the potential outcomes that we want to see as a result of our negotiation process. Now, fair and affordable financial terms is a key outcome, but also minimizing the risk and liability for the tenant is very important, because for most of you, again, that have signed a lease personally, we ideally want to transition that lease to, say, your professional corporation to ensure that you're not personally guaranteeing to pay in a rent. So those outcomes are critical. We actually want to map them out in advance of contacting the landlord and understand what the step downs are. If we approach the landlord with a significant change in the lease and the landlord is not amenable to that, how do we reach a compromise? What are the step downs to obtaining that, say, death and disability provision that still get you added protection, but also make the landlord satisfied with the way it's written in the lease agreement? After we identify the potential outcomes, this is, again, prior to contacting the landlord, only then do we contact the landlord with respect to negotiating the financials of the lease agreement. And the negotiations of the financials is primarily geared towards negotiating rent, the base rent, and as well as any additional rent. And for those of you that are on a triple net lease, many of you do not have any sort of limitations on how much your common area maintenance fees could increase by year over year. And so if you only pay attention to the base rent figure and only negotiate the base rent with the landlord, you'll be surprised to find that the landlord can essentially still collect a higher rent by simply having you pay a greater proportion in terms of the total rent and contribute more towards the operating costs and expenses of the property. And many of you are not even getting audited statements with respect to those expenses, and you have no idea of how the landlord's coming up with that number. So after we negotiate the financials, the rent rates with the landlord, as well as any sort of tenant improvement allowance if you're looking to paint your office or change the carpets, if you need any sort of contribution to remodel the space, we'll then start the process of documenting all the lease language changes that we want to table to the landlord. And so what I mean by that is every single provision that needs to be altered within the lease agreement, we have to provide the landlord with the right language to insert into the lease, or if it's an amendment process, to keep the landlord's cost at a minimal from a legal standpoint, we want to essentially write the language that we need to have in the lease agreement. If it's not there, if the language is not favorable or is very one-sided, we want to rewrite the language to ensure that your rights are protected and that you're provided with additional cushion if things go wrong. And so documenting those provisions is a very cumbersome and time-challenging task, and it requires expertise when it comes to the legal implications of these clauses. But more importantly, it's important to be prepared to go back to the landlord dozens of times until we settle on the language that the landlord feels satisfies their conditions, but at the same time also meets your requirements. And so up to this point, the process from start to finish could have taken anywhere from 4 weeks to 6 months or 8 months. Again, this is why you want to start the process 24 months in advance of the negotiation to give yourself enough time to negotiate not only the financials of the lease, but also the legal provisions within it. So we've gone through the 6 steps, and we finally got a final copy of the lease agreement that both us and the landlord has agreed to. So what do we do then? The landlord has just sent us 3 copies of the final lease to be executed. What many of your colleagues might do in this situation is they might go ahead and put pen to paper, not having read the lease that they presume to be the final copy of the lease from beginning to end, from cover to cover. What we find is more than 60% of the time, when we get to the last stage, which is the final review and execution of the lease agreement, the final copy of the lease that we're provided with is actually still a draft. It's not even, in many cases, anywhere close to what lease terms we had negotiated with the landlord. Now, when we contact the landlord, we often find that, they have an excuse as to why they provided us with the wrong copy or the draft copy and not the final copy with all the changes that we had requested up to that point. And so it's important, once you get the final copy of the lease agreement, that you actually read it and you track back to all the changes that you'd worked on to ensure that all the provisions are reflected in that final document. And many times, if a landlord decides to, for example, remove a clause in a particular section of the lease, they may actually reinsert it into another section of the lease agreement. And if you don't read the lease from beginning to end, you're going to miss out on that particular instance of that clause that was essentially taken from one section but reinserted into another, which still gives your practice a lot of liability and exposure. Now, I mentioned earlier with respect to the work that we do with analyzing rent rates and vacancy rates, and for every single lease that we negotiate, and you can do some of this research on your own through online resources, but the charts you see in front of you, so the first one is actually a building report on the left-hand side of your screen, and it talks about what the history is of that particular building with respect to when it was built, who the current recorded owner is there any sort of financing or mortgage on the property, what is the total vacancy rate available, how many parking spots are there, how many floors, what is the total square footage, how much did this particular landlord pay in taxes in 2013. So this information was directly pulled from one of the databases that we subscribe to that most large institutional landlords also use. It isn't cheap, but you can do some of this research on your own through online resources. Now, the number one mistake I see a lot of doctors make when it comes to researching rent rates is they rely on word of mouth, what other tenants say they pay within their particular building, and what is essentially published online with respect to comparable properties. Now, realize that if you're looking at other properties in the area and you're relying on information that's provided by brokers, that a lot of times this information is essentially marketing or advertising information. It's really intended to solicit offers, and the rent rates that you see advertised are not actually rent rates that tenants agree to, because after negotiating any lease, the final negotiated rent rate could be higher or lower than what was originally advertised, because some tenants will want to have a larger contribution as far as a construction allowance or a tenant improvement allowance, and that's going to certainly skew the rent rates that they finally agree upon with the landlord. And so if you're relying on comparable data, it's important to look at similar information in terms of medical offices, compare yourself to similar tenants, and more importantly, look at deal done information. Don't look at advertised data. Don't look at the medical office space that's being advertised in the local directory and assume that most landlords are charging that exact rent rate. And the only way to really access deal done information is to subscribe to some of these landlord tools that provide you with the intelligence you need to essentially pull out comps, pull out comparable data that will arm you with the right set of facts to go into the negotiation. The other one that we'd like to look at is with respect to vacancy rates and forecasts. And this is a diagram that essentially shows you, going back to 2009, what vacancy rates have been like. This particular chart is within a 3-mile radius of the medical practice that we are working with. And so understanding that vacancy rates have actually been on the decline and currently hover at a low of 2%, while rental rates are on the rise, have been increasing since 2012 quite substantially, puts us in a position where if we're going to approach the landlord, we're certainly not going to, for example, go in and ask for a rent rate of $15 a square foot, knowing that the rent rate today is actually an average of $21 a square foot. So you have to understand what's going on in the market to be able to position your request for either a rent reduction, or alternatively, if changing the legal provisions within the lease is more important to you, sacrificing an additional 50 cents a square foot to reduce your practice liability. If there's one thing I want you to take away from today's webinar, is the notion of when to start the negotiation process. And I'm going to bring this diagram up again because the tenant lease cycle is something that every single landlord across the country uses to manage their lease portfolio. And once again, the notion of leaving your lease renewal until the last minute is a bad one, because again, what happens is when you approach the landlord with anything less than typically 12 months of term, you are put in a position where you're bound to pay more rent, because the landlord, again, knows for every month that goes by, you lose leverage. And many times they'll ignore you for as long as possible until you get close to the expiration date. And starting the process 24 months out, contacting the landlord, having the ability to contact the landlord multiple times will ensure that you can bring them to the table and that you can commence the process. And what we typically do is, if we don't hear back from the landlord 24 months prior to the expiration date of the lease, what we'll then do is we'll actually send them a real estate prospectus that will identify multiple properties that are currently vacant that our tenant, our doctor, can potentially relocate to. And oftentimes when we send this real estate prospectus to the landlord, it immediately gets their attention, because the next thing they're wondering is the doctor really looking to move? They must be, because they've just surveyed the market and understand what office is available, what office space is available, and it gets their attention. Although landlords like to delay the negotiation process, they certainly value your tenancy. They don't want to lose you as a tenant, and when you have 24 months left prior to your expiration date, if you don't hear back from the landlord, at least you have sufficient time to plan for a relocation if you're forced to. But what we find is most landlords, after multiple contacts and after we send them a real estate prospectus, will turn around and will immediately want to secure a long-term lease, because they don't want to risk losing you as a tenant, and they realize that your intentions are serious. So whether you're a doctor who's looking to start or open a practice, relocate your practice, transition or retire, or renew your office lease, or you're simply looking to expand, no matter where you are within your medical career, a properly set up lease can help you save hundreds of thousands of dollars in risk and costly mistakes. And in summary, the details of your lease can cost you a lot of money, and it's not really just about rent. Don't get me wrong, rent is a very important aspect of negotiating a lease, but it's not the only aspect of it. Minimizing risk and liability is very important as well. And we want to ideally achieve long-term peace of mind. And so for most of you, again, what it means is you want to secure a 10-year lease with options to renew, and you want to have that provision that gives you the right to exit, if something goes wrong and you can personally practice medicine. Now, I do have a question with respect to what is the right to delay in a lease? And so the question that was just asked, I believe the attendee is referring to whether or not there is a right, and maybe you can elaborate on this, with respect to actually delaying, meaning does the landlord have the right to delay negotiations? There's nothing within the lease agreement that says that the landlord has to respond to you, acknowledge your need to renegotiate a lease. The only time that right is there is in the event that you contact the landlord and within your lease, it specifically states that you have an option to renew or extend the lease, and that option to renew has to be exercised by a certain time. Typically, it could be 6 months or 12 months prior to the expiration date. If you notify the landlord within the required timeline, the landlord typically has to acknowledge your request. But many times, they don't have to legally negotiate or renegotiate your lease when you went to exercise your option. They have the need to abide by the terms of the option to renew, which means, for example, to give you an additional 5 years of term, but whether or not the terms of that extension are favorable to you really depends. They could delay negotiating that particular extension deal until your lease is about to expire, and if your option to renew provision is not properly structured and you're exposing yourself to a rent increase, they will then table a rent increase, and at that point, with 30 days left until your lease expires, you're not in a position to essentially relocate your office. And so most of you and your colleagues are going to agree to an increase if the landlord has delayed. And again, the key there is just timing, ensuring that you're contacting the landlord well in advance. And if they're not responding to your request, that you take it a step further and you communicate to them that if you don't hear from them, you have no choice but to move your office. And most landlords will take that very seriously. You're not threatening per se. You're just saying to them, this is important to me. It's important to my patients that I secure and I continue to secure a long-term stable practice. And this lease agreement obviously plays an integral role in allowing me to achieve that. The other question I have from one of the attendees is, after commencement of fixturing, and I assume that you're going to be, in this case, building a clinic, if there's a delay in opening and it's caused by the landlord's negligence, what remedies are available to the physician, especially if they have lost income? And so in most leases, unless you've specifically written this in the lease agreement, you typically have very little way to collect lost income. What most landlords will essentially argue is that if you've lost income, you should actually file a claim under your insurance for business interruption. But the challenge is when you've just undergone the process of building a clinic and the landlord has delayed delivering possession of the space due to their negligence, and it could be because, for example, construction was delayed or the work of the general contractor was not up to par and some of the work had to get redone. And so if there's delays there, unless you've built in penalties in the lease agreement, you have no way of seeking damages. And landlords intentionally, when they write these leases, they write them in such a way, always assuming that there will be delays, and they don't want to be held responsible financially for those delays. And again, smart tenants will negotiate penalties so that if the commencement date gets pushed out, if they don't assume possession of the space within a specified time period, that they either can walk away and not be obligated to lease the space, or alternatively, they obtain, for example, a rent-free period where because of the delay, they're not actually going to pay rent when they don't have the keys to the space. But more importantly, even when they open up their practice, the landlord essentially, out of fairness, has granted them several months of rent abatement to essentially make them whole again. So it doesn't look like there are any other questions. I do want to wrap up. So if any of you are currently in the process of either renegotiating a lease or starting a clinic and you need to negotiate an offer to lease or letter of intent, all of you are eligible for a complimentary lease consultation. You can contact me directly with respect to that. And what we'll typically do is If there's any questions that were not addressed in today's webinar, if you have specific questions regarding terms you've already agreed to, we'd be more than happy to give you guidance on these terms and ensure that you as well as the practice are protected. So I want to thank everybody for joining today's webinar. If you do have any follow-up questions, I know that there's a lot of content to be presented on these webinars. So if you have any questions that come to mind after today's session, please don't hesitate to either email me or give me a call. We're very accessible, and we certainly look forward to helping you to get into a better lease agreement.